and remotely. Just to say a little bit about this, I'll just read from the, and I want to introduce my colleague Oliver Reyes, who's an attorney in the Philippines and works with me at APrIGF, who helped develop this panel in conjunction with OpenNet Korea. Digitization is bringing new questions and challenges to the understanding of what is private and public and what criteria should be used to decide this. While the discussion on privacy in the digital age is hitting its peak, the discussion on publicness has only been approached from the perspective of freedom of expression or access to information. Particularly, the discussion on the right to be forgotten is being wrongly placed in a privacy context discussion when actually it is a discussion about the visibility of public information, which is in the realm of the freedom of expression and the right to know. Therefore, enforcement of the right to be forgotten creates tension between privacy and publicness. Media and public interest groups who collect and publish personal information in the course of their civic duties are especially at risk of being wrongfully censored in the name of the right to be forgotten. Courts in Asia will increasingly be called upon to negotiate these tensions. A wider discussion on the legal implication of the right to be forgotten is warranted to ensure that all perspectives are considered as the right is increasingly enforced. Right to be forgotten is an enforceable right. A right to be forgotten as an enforceable right is finding wider application across Asia. The need to discuss and understand the different conventions and expectations on publicness is essential, and that is what brings us here today. The American Bar Association is an organization of 400,000 American lawyers, just think of that. And so we have, as part of that association, the Rule of Law Initiative works internationally to promote the rule of law. We've worked in over 100 countries around the world and currently have programs in about 60 countries. Our international programs were established first in 1990, and we began our work in Southeast Asia in 2003. We are conducting an Internet Freedom Program based out of Manila, and working very, very closely with us is a newly formed organization. Although it's been conducting activities for some time, it just formalized just at the kickoff of this IGF. They formalized, and I'm very, very pleased to be working in partnership with APrIGF, the Advocates for Freedom of Expression Coalition Southeast Asia. They represent 6 countries at this time: Malaysia, Indonesia, Thailand, Cambodia, Myanmar, and the Philippines. And their chair, newly elected chair, Gilbert Andres, is here, and he will be addressing you. Right after the panel, he'll make a short statement about the right to be forgotten and introduce APrIGF to you. It's a very exciting new organization of lawyers, journalists, and other advocates for freedom of expression around Southeast Asia. I want to introduce, before I turn it over to Dr. Park, I'll introduce the panelists that are being presented by APrIGF. I'd first like to introduce Katie Townsend, who is on my right. Katie is the litigation director at the Reporters Committee for Freedom of the Press, an unincorporated nonprofit association of reporters and editors based in Washington, D.C. Katie oversees the direct litigation work of Reporters Committee attorneys and represents the Reporters Committee news organizations and individual journalists, including investigative filmmakers in court access, freedom of information, and other First Amendment and press freedom matters. To my left is Attorney Francis Achero. He is the Chief of the Complaints and Investigations Division of the National Privacy Commission of the Philippines. He is a founding member of the Philippine Internet Freedom Alliance and of democracy.net.ph, and is a member of the Internet Society Philippine chapter, all of which are initial organizational signatories to the Philippine Declaration on Internet Rights and Principles. So that is a brief introduction. I'll turn it over to Dr. Park, who will give his introductions, and then we'll start our panel presentations.
Hi, my name is K.S. Park. I'm a law professor in Korea, also board member of OpenNet Korea, which is a digital rights organization of the country working on freedom of expression, privacy, net neutrality, intellectual property, open data, internet governance, etc. I'll be speaking, and Kelly Kim, to my left, is a staff lawyer of OpenNet Korea. She will also contribute to the discussion by presenting a regional case study of Korea. She is a lawyer specialized in privacy and technology and freedom of speech, and has engaged in many high publicity cases before Korean courts. The second panelist that I'll be presenting remotely is Toshiki Yano. Toshiki Yano, T-O-S-H, just for the transcribers, T-O-S-H-I-K-I-Y-A-N-O. He is representative of Google Japan, who will give the private sector viewpoint on in this multi-stakeholder discussion. So with that, I'll turn over to Mark so that he can turn over back to me.
And back to you, Dr. Park.
Okay.
Please, our first panelist, Dr.
Yes. Can we have the presentation on? Well, I can start while they are fixing. Right in this room, we talked about freedom of expression in Asia in the previous session. We talked about how criminal laws are used to suppress internet freedom in the region. I also achieved my fame in the country as a freedom of speech advocate, and you saw the reality in Asia, where defamation laws, okay, next slide, defamation laws and insult laws, and also the laws criminalizing insulting authority, also the laws of blasphemy are used to suppress freedom of speech. And these are all different theories of suppressing true expressions, or expressions not yet proven to be false. So these are the laws under which, even if you are speaking truth, you can be punished or your statement be suppressed. Compare the reality against the international standard. One international document is salient. 2010 UN Human Rights Committee's General Comment 34 on freedom of expression specifically said, truth shall be a defense to any form of defamation law. So if you are speaking truth, you cannot be punished even if it is lowering another's reputation, or it is insulting somebody, or even insulting the king, or insulting religion. And many of these laws have exceptions. Many of these recognize truth as a qualified defense, saying true statements will be exempt from punishment if it is for public interest. But I checked with the UN Human Rights Committee that defense should not be qualified, should be complete. As long as you are stating truth, even if it is not proven to be geared toward public interest, you should be able to speak that. People are worried about privacy infringing truth. forced coming out on sexuality, marriage. But for privacy, you need another law, not defamation law. Otherwise, employers not paying wages will claim privacy on their conduct, can suppress, and then can suppress employees or prohibit employees from criticizing them for non-payment of wages. This has happened in Korea because Korea has truth defamation law. An employee was actually punished for complaining aloud that his employer has not paid wages. In general, people committing crimes secretly, and usually people commit crimes secretly, will claim privacy upon their conduct. You cannot use defamation law to protect privacy. Next. Then in 2014 came this right to be forgotten jurisprudence from Google Spain case. It was about Spanish lawyer wanting to be forgotten by his peers about the fact that he fell behind on his social security tax payments, so behind so that his house got auctioned. And he requested to delist auction information from search results when search is done based upon his name. Now I'm going to talk about what it is not. It is not about punishing people for statements. It is just punishing statements. It is just suppressing circulation of statements. And it's not about punishing all true statements. It's about suppressing just statements that are, quote, no longer relevant. And it's not about taking down all no longer relevant statements. It's about delisting from search results. And it's not about delisting that information from all search results, but just on the searches using the data subject's name. Even so, even with all these limitations, it's still a new theory upon which truthful, non-privacy infringing statements can be suppressed. That's why it hits Asia in a very negative light. It really provides very negative background upon which Asia's freedom of speech can be demoted once again. Now, these are justifications for right to be forgotten. People say right to be forgotten is needed for privacy. They cite former prostitutes who want to have a second chance on their lives. They talk about children who have posted self-nudities. But I have no problem with that. You don't need the right to be forgotten to suppress those images and those texts, because the classical rules of privacy can allow the former prostitute children to take down those images and text, because prostitution by nature is a private profession, and a child by law doesn't have legitimate power to consent to a disclosure disclosure of his private information. But the problem with the right to be forgotten is it applies not just to private information, but it applies to public information. To be accurate, information voluntarily made available to the public. I'm not talking about just information that's actually made public, but also information that's made constructively public. For instance, if you commit some conduct and attract attention from police, hospitals, and media, you cannot expect to be kept private on your conduct. The second justification usually provided is people should be given second chances. And right to be forgotten is really about right to be forgiven. But is it really a proportionate and effective measure of seeking forgiveness to prohibit your peers from talking about your past? Or will the society progress more if people can freely talk about those things and actually gauge the ethical value of those conduct? The third justification is that it is a digital age and we need data protection, but can you really own data about you, right? Can data really be owned? Think about Jane, the wife. and Jim, the wife beater. Let's say the data about wife beating between Jim and Jane. Who owns that data? Jane wants to talk about that. Jim wants to suppress it. Who should own it? And also, the fourth justification is that it applies only to the information that's no longer relevant, and that if the information is publicly interested, then it will not be subject to right to forgotten jurisprudence. But not relevant to what? I mean, the information, whoever uses the information can be very creative about for what purpose the information will be used. And also, in Asia, there are many remnants of former dictatorship and former colonial regimes that still affect the current society. And to properly redress those injustice and oppressions, you need the whole truth, not partial truth. And many times, you cannot really find out whether somebody is a public figure or not unless you get the whole picture. And Right to Be Forgotten suppresses that investigation into the whole truth. The final justification usually given for Right to Be Forgotten is that it's not really redacting the original information. It's not really harming the original information, but it is the suppressing availability of that information through the internet. My answer to that justification is this. Internet is a gift to human civilization. It is an extremely distributed communication system whereby control over data transfer is distributed to a myriad of terminals controlled by individuals. So it gives everyone freedom to make your messages available to the whole world, and gives everyone freedom to choose what message to view and receive. In this sense, Right to Be Forgotten is a discrimination against the internet because information is allowed to exist, but not allowed to be searched online. And you know how debilitating that can be to the availability of the information, because internet is a sea of information where if information becomes not searchable, it might as well not exist. So we will be, if information on the internet is censored this way through Right to Be Forgotten, we'll be back to the pre-internet age, where only the people with the resources will hire other people to go through different websites and databases, because the search function cannot be used. And the individuals will have to rely on manipulated search results. So we have to think about this new concept, publicness. Data protection law, I strongly believe in data protection law, and I think that every country should have data protection law, but it is a temporary measure because it relies on extremely libertarian idea that you own data about yourself. It is still needed to protect the privacy of people who are turning over their data to governments and big companies, but it should be limited to the information that they have held confidential, that they've held private. It should not be applicable to the information that was voluntarily made public, or that was made available to the public by reason of the data subject's conduct. So Right to Be Forgotten fails in that regard because it applies to publicly available information. What is publicness? Responsibility as a social being to allow space for others to approach you and contact you. You cannot expect others not to perceive you after you, when you share physical space in which you form society, you form a relationship. It creates ethical space. Another way of looking at it is publicness is collective rights to evaluate one another, to perceive one another, share in the feelings of one another. We should think about publicness as a concept before we jump on to Right to Be Forgotten. At Global IGF, a dynamic coalition on publicness was formed in short, it's called the DC Pub. And we are working on a statement on right to be forgotten. If you are interested, you can Google about it. You'll find it. And if you like the statement, you can sign on. Thank you.
Okay. Dr. Park is expert in a wide range of issues related to internet governance and always gives a thought-provoking presentation, and so we thank him for that. And I know we're going to have lots of questions and lots of things to talk about. I'll turn now to Katie Townsend, who will provide us a global as well as a U.S. perspective on the topics.
Thank you, and I'm very pleased to be here. As a lawyer who represents journalists and news organizations in the United States, I very much approach these issues from a US-based media perspective. So getting that out there from the beginning in the interest of full disclosure. I think it's useful to think about the right to be forgotten in sort of quotations, the issues surrounding them in sort of two major buckets. I think the first one is really the substantive policy questions, and these include sort of what is the right to be forgotten. I think there's, is it a right to demand delisting from an internet service provider or a search engine like Google? I think that's the sort of European Union view of what the right to be forgotten is, as Dr. Park pointed out. Is it the right to demand that an ISP or a publisher, in the first instance, remove content that is on, that they've published or that they're hosting on a site in the case of an ISP? There have been cases in Belgium, for example, and in Italy, where news archives were found to be sort of liable, I shouldn't use the word liable, but responsible for responding to a right to be forgotten demand by removing a news article that was, I think very tellingly in the words of the Italian court, expired in the same way that milk expires. It was irrelevant precisely because it was sort of dated old news. So I think that's an important sort of threshold question. What are we talking about when we talk about the right to be forgotten? And also, what is the content that this quote-unquote right sort of reaches? As Dr. Park said, in the EU, it is very much the sort of irrelevant content, although he made the point excellently, what does that mean to be irrelevant? Sort of irrelevant to what? I think these are the tough sort of substantive policy choices that really go to the heart of what I think is at the core of the right to be forgotten, which is attempting to strike a balance between two competing interests. On the one hand, you have privacy, and on the other hand, you have free speech, free expression, which of course includes the fundamental right to gather and receive information. With respect to the U.S. approach, I mean, I think it's fair to say that the internet itself, the sheer availability and ease of availability and obtaining information about individuals through the internet has really created an anxiety about privacy rights. And certainly in the United States, we are not immune to that anxiety. I think for the most part, it has manifested itself in different ways. So the U.S. has a very different conception of privacy than countries within the European Union. Indeed, I would say probably every country in the world other than the United States. That being said, the U.S. has not been immune, again, to these concerns about privacy that are really driven by use of the internet. We've seen, for example, increased use under Freedom of Information laws by the government of privacy exemptions designed to protect information that the release of which would cause an unwarranted invasion of personal privacy, for example. And in fact, there have been state legislatures within the United States that have dabbled in their sort of own versions of right to be forgotten-ish legislation. California in 2015 passed an eraser statute, which is quite narrow, particularly when you compare it to sort of the new concept of right to be forgotten, but it is effectively only applicable to minors and gives minors the ability to request that information that they've posted on social media be removed. More recently, the legislature in the state of New York has proposed a bill that mirrors more closely a sort of what we think about when we think of right to be forgotten, more of a delisting type right. That none of these laws have been challenged constitutionally. I think there are very real questions under the American system whether these would pass constitutional muster under the First Amendment. I think, as a person who practices First Amendment law, that I would not think that they would. But again, they haven't been tested, and these are sort of isolated pieces of legislation throughout the state. And so I think that, I'll pause there on the sort of substantive policy issues, but I think it's very important to think about these issues from the outset. Not to say that the American approach, which again I recognize is very different from other countries with respect to privacy, is the best and only approach. That being said, I think when it comes to striking that balance between privacy and free expression, it's really vitally important to recognize that the right to be forgotten, whether you're talking about delisting, i.e. making links to content inaccessible, and when you're talking even more so about removing content itself, you're affecting free expression in a very real, practical way. I think the second bucket of considerations and concerns, particularly felt by the media in the United States, is the potential extraterritorial applications of first right to be forgotten type laws and other types of internet restrictions as well. The Reporters Committee, the organization that I work for, and a group of media organizations in the United States, for example, filed amicus briefs with French regulatory authorities when those regulatory authorities sort of took Google Spain, that decision, and went beyond that to attempt to require Google to remove or delist links, not simply on the EU domain, but on the Google top-level domains, google.com, in other words, impacting what would be available to a Google user in the United States, and frankly around the world, not just the United States. This is very deeply concerning because obviously the standards that the French regulatory bodies are applying to making the determination as to what should be delisted, very different than what would be applied in the United States. If the United States government attempted to require Google to delist information or links in the same way, that would most assuredly be contrary to the First Amendment, an unconstitutional act by the government. So it's a very real concern. I think that decision, coupled with other decisions that affect sort of the extraterritorial application of a one jurisdiction's law sort of across the board globally, have sort of heightened that concern. I think just very recently, the Supreme Court of Canada issued a ruling not in a right to be forgotten case, but rather in sort of a trade secret case, requiring that Google remove or delist links to a website that was essentially selling sort of counterfeit goods related to the company that was the plaintiff. The case is Google against Equistec. In that case, the Canadian Supreme Court determined that it could enforce an injunction against Google requiring Google to remove those links globally, meaning on google.com, not just on Google.ca, the Canadian domain. That's a very deeply troubling development, even if you think of Canada as a country with very strong human rights and protections for freedom of expression, which it is. It's still very troubling. In fact, Google just earlier this week filed a challenge to that in the United States in the Ninth Circuit, challenging that injunction under the First Amendment to U.S. law. So these are concerns. I think Google, the best way to sort of characterize what the sort of underlying concern here is, I think Google characterized it the best in its briefing to the French regulatory authorities with respect to right to be forgotten, to say that this would encourage repressive regimes to attempt to enforce their rules their laws on the internet globally. So one salient example you might think of is a European blogger writing about LGBTQ rights or advocating for those rights directed at a European audience. That would be in violation of Russian law. Does that mean that Russia can then demand that Google delist that site from google.com? So these are very, very serious concerns. I think the biggest concern really from the US perspective, the sort of impact of these sort of attempts to extraterritorially apply right to be forgotten and other laws. So there are other procedural considerations we can discuss as well. For example, whether or not in the delisting context, Google search engines, ISPs need to notify publishers that material is being delisted, or even permitted or prohibited from doing so, or permitted to do so. But I don't want to spend a lot of time on that, so I'll send it back to Mark.
Toshiki, are you there?
Yes.
Okay.
Sorry.
All right.
Too loud.
Yeah, it's your turn. So again, Toshiki is a representative of Google Japan, and he's going to give the private sector point of view in this multi-stakeholder dialogue. Go ahead.
Okay, thank you. Operator, please mute. Echo. Okay. Professor Park, can you hear me? Please show me a sign.
Everyone can hear you, not just me. Go ahead.
Can you hear me?
Yes, we can hear you. Go ahead.
Okay. Sorry, my screen is frozen. So, first of all, I'd like to say thank you for the moderators and Professor Park, especially inviting me by attending through online. I really wanted to go to Bangkok, but this time I have a difficulty. So please allow me to attending by this online. So I'm Toshiki Yano, based in Tokyo, working for Google, and my role is a public policy and government relations counsel for Asia Pacific as a whole. So I'm now overseeing Asia Pacific region and in privacy and relevant issues. So today I'd like to tell my observation from private company, in particular from the look from Google about the right to be forgotten discussion in Asia Pacific. So for me, from private companies' perspective, I think Asia Pacific policymakers, lawyers are trying to strike the balance between free speech or public benefit and privacy, or people's demand to delist their information from search results, which means I think APAC people are smart enough, very well consider how to strike the balance. So not to try to just import European right to be forgotten notion in a simple way. So they try to adapt the new notion based on their own culture, their own understanding of the privacy, which is, I can fully support that. For example, there is a new law in Indonesia that can order electric system providers to remove, take down the information from certain individuals, but if there is a court order. So without court order, there is no such right to delete. So that were considered, and following that law, passing of the law, the ICT minister commented the range of range of the application of the new law will be limited. But the country is now discussing how to implement this law. So it's not clear about that yet, but I think initial discussion in Indonesia is very much will considered. That's one thing. And the two, for example, in Korea, April 2016, the KCC, the Korean Communication Commission, issued a guideline regarding so-called right to be forgotten. But when you see the content of the guidelines, it's not legally binding, but anyway, such administrative guidelines. It says go to webmaster, web owner first when you want to delete some information because it's effective. Because ultimately, if you successfully delete information from search results, still your information will be remained in original webmaster's website. So that the Korean guideline indicates first go to the webmaster first principles, which is I think we're considered too to strike the balance. And the third, in Japan, in January, the Supreme Court issued a new decision regarding so-called right to be forgotten in Japan, but the court clearly states there is no need to create a new rights called right to be forgotten, and then show the very balancing test. Whether it's a public figure's information, there is any public benefit to access such information, any any bad harm against the individuals by listing such information and so forth. And then the court concluded in the case there is no need to delist. And the court also stressed the freedom of speech of search engines, and as well as search engines' social role as a social infrastructure to distribute information to the public. So the court is showed a well-balanced approach, and then how such court decision will be implemented in Japan will be the future discussion. But the justices of the Supreme Court showed a clear balancing test. When you look at outside of Asia, in Latin America in particular, there's some good court cases we can consider. Which is for example, what I had is Colombia, Argentina, and Chile. There are some court cases. Some of them come from their own Supreme Court, and then it shows a search engine should not be responsible for any listing request and so forth. So I haven't read the court decision in detail yet, but again, we can know how the courts or lawmakers or lawyers are struggling to strike the balance and not to just imitate European laws. And the additional information is European people themselves are very much struggling for how to strike the balance between free speech and the privacy. For example, the latest news from Spain is the Spanish National Court dismissed a decision by the local data protection authority, finding that the right to be forgotten does not apply to criticism about a public figure's professional conduct, and that court also said the right to be forgotten is not a right to rewrite one's past. It's a decision from Spain in this month or late June. So we need to take a look at the details, but Spain is the origin of the right to be forgotten, as Professor Park said. But still, they are struggling how to strike the balance. So we should consider our own notion of right to be forgotten, whether it's necessary, if necessary, how the range would like to be. So we should be super careful about not to, just looking at European practices as a kind of a textbook for ours, because we need to consider by ourselves. That's one thing. And if we can split the discussion into two, maybe from my perspective, first stage is whether we need right to be forgotten in APAC. That's one thing. And if we need it, in two, second, how the range of the application. But I observe we are still on the stage one, whether we need a right to be forgotten. So including Japan Supreme Court's decision, we APAC people are still trying to solve the issues by using existing legal principles. So probably we can solve any arising issues by our own laws, existing laws. with minimum improvement. So my point is we should think by ourselves, just looking at Europe, not just looking at Europe. That's my point.
Thank you, Toshiki.
Okay, Professor Park, that's all from me so
Okay.
far.
All right, Mark.
Okay, great, and thank you so much for that presentation. It was great to have you with us, even if remotely. Let's turn now to the Philippines and to our friend attorney Francis Achero.
Hi. I'll be talking about the Philippine context. We don't have a specific right to be forgotten statute. It's buried in the provisions of our data privacy law. I think see if the slide can catch up. All right. So while we're waiting for them to catch up, I guess we can talk about it first. Inside our data privacy law, we have what we consider to be the rights of data subjects. And a specific right is to have the right to have an inaccuracy or an error in your record corrected. And if the controller is not able to correct that record, the data subject has the right to have that record erased or blocked. So the text of the law does provide that. It'd be better if it was there. Anyway. Okay, two more screens forward, please. All right. So the law does say that when we talk about the right to erasure blocking, it's for incomplete, outdated, false, unlawfully obtained, used for unauthorized purposes, or no longer necessary for the purposes for which they were collected. Now, in Philippine data protection law, that purpose has to be specific and given at the moment of consent. You cannot expand on that purpose for more, for any other reason than what you've already told the data subject. Next slide. So when we interpreted that in our implementing rules, next slide. So data subjects have the right to demand from their controllers the right to suspend, withdraw, order the blocking, or order the removal of personal data. And they can also demand that the controller or require people who have received that information down the line to change that information. Next slide. So you can see that there are two forms, two rights that are actually within this right. The first right is the right to accurate information. Right to accurate information. So when the data is wrong, you can have it changed, and if they can't do it, they have to take you out. The second part is properly the right to be forgotten. So if the data subject says, I withdraw my consent, please remove me from any record that you have of me, then for any reason, then that record has to be expunged. The second part is when the data is prejudicial to the data subject, and then there's a big caveat. Our caveat is, unless justified by freedom of speech, expression, or of the press, or otherwise authorized. There are concerns that I heard earlier about public interest requiring that data to be kept longer in terms of professional or ethical standards. And we think that it's best kept to the regulatory agencies to determine what kind of information that is. So that's otherwise authorized. In terms of free speech, expression, or of the press, we refer to the public figure exception. So if you are a public official and it's the scope of the data is within your competence as a public official or goes into your public service, then that should be an issue. That shouldn't be subject to blocking. So we have that public figure exception in our jurisprudence. That's a senator of the Philippines. In 1986, there was a TV movie made starring Gary Busey. And he was one of the characters in that Romana Fleet. And in that production, he wasn't portrayed in a good light. So he tried to have that movie blocked. And in Supreme Court said that it adopted the book on torts of all subjects, saying that public figures cannot keep their right to privacy, and you cannot invoke the right to privacy to resist publication. You expand that into data protection law, and a public figure cannot insist on the right to have negative information about him blocked because he's already a public figure. Now, our public figure exception is so broad that more or less it says that if you are newsworthy, then you don't have that right anymore. So, which brings up questions of Streisand effect. If you do insist on the right to be blocked and then right to be forgotten, you'll probably be the first one, and then you become a news figure, and then you lose your right. So it's kind of a chicken and egg question at the moment. But the idea is that if you are a private person and you have changed your life, and that information reflects something that isn't you anymore, and you've stayed out of the light, why not? Now, we've had one case involving a right to be forgotten, and it involved a rape case. Now, in just before I passed the bar, there's a law passed called Anti-Violence Against Women and Their Children Act. And in that law, the records of victims are supposed to be kept confidential. So anyone who's published the name, telephone school address, business school, or any identifying information, this is long before the Data Protection Act, they'll be subject to contempt proceedings. The Supreme Court noted this in a later case, and it's People versus Capalquinto, and it came out in 2006. And they noted that, well, victims of rape cases do need protection, and if they're going to move forward with their lives, it shouldn't prejudice them just because their case makes it all the way through the judicial system. The problem is when we have 100 years of, well, at that time, 90 years of tradition where in rape cases, the names and the details and all the salacious whatever, they're fully reported in the case. So the court said, okay, from this point on, the names and other personal details will hide them with initials. And so all victims from that point on have become AAA. Now, there's this lady who called us up just after we were formed in last year. And she asked that she be taken out of a online database or online court decision database. The problem is her case came out in 2000, and it's way before the application of the 2006 case. So she wanted her details changed from her name to AAA because she said that she's been having a tough time moving on. She's around 41 now. And this happened when she was 15. So she was having a really tough time. So the Supreme Court already changed their reporting. So her case is now initialed. Her name is gone. But other case reporting websites, which take details from the Supreme Court website and put it on their own, have kept her name. So we reached out to those websites and some complied, some have changed their names, but there's still one holdout. And we did, the only checking that we did after this was a Google check. Because we noted that once the changes were made, her name quickly disappeared. And that was so, they complied for a couple of months, and then we saw again today that, as I checked this morning, her case went back up. So we'll open a file and investigate that further. So that's it.
Thank you, Kiko. Let's turn to Prasant Sugatan of the Software Freedom Law Center out of India.
Good morning, everyone. My organization is Software Freedom Law Center in India. We are part of an amicus brief filed in the Google case in France. We were part of 18 organizations who filed an amicus. See, the problem, this is an evolving area. The jurisprudence is evolving. So any decision in any part of the world definitely is going to affect other jurisdictions. Yes, in this current case, we know when Spain sneezes, the rest of the world can catch a cold. And we in India were like no exception to this. We have now seen like a spate of cases involving the so-called right to be forgotten. And it is really interesting. We in India live in interesting times where in a litigation before the Supreme Court where the national unique ID project was being challenged, our highest law officer, that is the Attorney General, submitted before the court that we Indians do not have a fundamental right to privacy. And that could be strange, like in this age, somebody saying that you don't have a fundamental right to privacy. But yes, that is being debated now. A 9-judge bench of the Supreme Court, that's a constitutional bench, is debating whether Indians have a fundamental right to privacy. In this scenario, we also find lawyers and courts who are enthusiastic to import the Google Spain case and its doctrine onto the Indian scene. And the funny part is that we don't even have a data protection law. So if you look at, as Professor Park was explaining, the Google Spain case, it is essentially based out of the data protection law in Spain, in the Europe. And where the search engine was considered to be data controller. But as far as India is concerned, we don't even have a data protection law. But still, there have been many cases where people approach the courts asking their content to be taken down, the search results to be removed. So far we have followed in cases we have a federal structure in various states, various high courts. We had one in the Karnataka High Court, one pending in Delhi High Court, one in the Kerala High Court, one decided in Rajasthan High Court. So this has been going across the country. In fact, in one specific case, again, I think in some cases the media also has to blame. Everything sometimes gets painted as a right to be forgotten case, which is not the truth. As the person from Philippines was mentioning, even in India we have a law which specifically deals with rape victims. And they have a right that their name not be revealed. And one case was specifically pertaining to that. So it was not exactly a right to be forgotten case that way. That was specifically, there is a specific provision in the Indian Penal Code which provides that a person, a victim in a rape case, her name cannot be revealed. So even if it is in a judgment. But what could happen was there could be some related cases where her name is revealed and people could make out. And currently pending cases in the Kerala High Court and even in Karnataka High Court pertaining to that. But even that gets often reported as a right to be forgotten matter, which is not true. But then there are other cases. I think there are a couple relating to marital disputes where the husband wants his name to be removed from decisions relating to his marital disputes with his 12th wife. he wants it to be removed from search engines, from in most cases nowadays, the decisions are reported online. Most of the High Court decisions are available online. These are then indexed. There are law reporters which index them. Apart from that, you can find it on Google also, Google and other search engines also. So they want all these to be removed. And as I said earlier, this is even without a data protection law. So currently, they want to extend the right to privacy. I mean, as I said, this is a debate which is currently going on. But they want to extend the right to privacy to include the right to be forgotten in that. But this definitely has to be seen from a different perspective altogether of right to people to know. In fact, yesterday there was a decision of the Supreme Court from India. This is a different matter altogether. The petition was for a stay on the release of a movie relating to the period of when emergency was imposed in India. The person wanted a movie depicting that, events related to that. It wasn't a fictional case, it was not a documentary. That she wanted that release of the movie to be stayed. But the Supreme Court said, well, a person's right to reputation cannot override the right of people to know. I think that applies very much here. We cannot see this purely from a privacy perspective, and it has to be seen from a perspective of a right to person to know, right for people to know. Otherwise, we will soon have a situations where, like search engine optimization, we will soon have like online reputation optimization kind of agencies coming up all over the world, where give them the price that they ask for, and you could clean your slate. I'm sure none of us want that. Thank you.
Thank you so much, Prasad. And last but not least, let's turn to Kelly Kim of OpenNet Korea.
Thank you. So I will focus more on like Korean situation. So according to the ECJ decision, so it is more concerned with the right to, a person's right to his or her own data. However, we are at APrIGF. I want to focus on how the right to be forgotten is understood and being enforced in South Korea. So first of all, Korea, I'm talking about South Korea, obviously. Korea is regarded as a country with a very strong data protection law regime, and data subjects already have powerful tools to enforce their right on their personal information, at least in theory. So according to the Personal Information Protection Act and the Information and Communications Network Act, a data subject may request a data processor or data controller to correct or delete his or her personal information that's been collected. And we don't have restrictions like those in Philippines data protection law does. And the definition of personal information is very broad. It seems to be forever expanding. So therefore, in South Korea, the right to be forgotten is more about rights to personal liberty, especially one's reputation. And reputation is only formed in a public realm. And the debate on the right to be forgotten revolves around the issue of how far a person's right to request cleaning of unsavory or unpleasant information on the internet stretches. So there are already so many mechanisms in Korea such person may use to purge the internet of unpleasant information about himself or herself. They are much more powerful than ECJ's the right to be forgotten, in the sense that it allows removal of the original information, not just the indexing or the listing. So for like defamatory information, as K.S. Park said, which includes true statements and inserting statements, is considered illegal in Korea. And the Korea Communications Commission, KCC, and its agency, Korea Communications Standard Commission, KCSC, has a power to order such illegal information to be deleted, apart from criminally charging the defamer. And any person who, and another mechanism is that any person who finds online information defamatory or privacy infringing may request intermediaries, the platforms, to take down the information. And it's not just the indexing or the listing. And the scope is very broad. As I aforementioned, defamatory information includes true statements, and also privacy infringing information includes information that contains personal information such as names and titles. So if certain information, certain contents include someone's names or titles like Professor Park's mentioning Professor K.S. Park or something like that, it's considered as personal information, and it can be privacy infringing information. And the intermediaries tend to comply with these takedown requests from the persons, and most of the time, and more than 500,000 online postings are taken down, deleted annually. Also, news articles are not sacrosanct either. Apart from journalists and news media often facing defamation charges or civil lawsuits, the Press Arbitration and Remedies Act provides the right to request for report on correct statement and the right to request for report on contradictory statement. So the news media must report. I mean, if a news article contains something wrong or defamatory, they have to report. I mean, according to the request, they have to report again those correct statement or contradictory statement. Yeah. And moreover, Korean Supreme Court acknowledges a cause of action for lawsuits to delete news articles themselves. So the problem is, these mechanisms to protect one's personal liberty are largely abused by public figures and private entities like professionals, companies, or religious groups. Unlike EU or Japan, we don't have a court case that specifically dealt with the right to be forgotten in Korea yet. However, the administrative bodies have been trying to catch up with the trend. So Mr. Yano already mentioned the Korea Communications Commission KCC's guideline. Sorry, I have a problem with my computer. And cases has the power to set standards and guidelines that are not legally binding per se, but ICT companies nonetheless, follow. Therefore, we are really concerned when the cases announced a plan to introduce the right to be forgotten guideline in year 2014. Initially, it seemed like a favorable adaptation of the ECJ's decision, which concerns, the linking or the indexing of information from the search results. However, after facing extensive criticism from academia and civil society, the KCC changed its approach. Yeah. And another one is bill proposed by the Press Arbitration Commission, and the bill allowed a person to request deletion of news articles, not only from the search result, but also from the server of the news media. Well, the bill didn't get to pass, but the danger still lies. So to sum up, at least in Korea, the right to be forgotten is not much about data protection or privacy. It's about how much of control a person should have over information that the person doesn't like, that is already on the internet, I mean, in the public realm or in the public domain. And I have a very different opinion from Mr. Yano that the balance between the public interest and the public and private interest and the public interest is well met in Korea. And I believe that this broad application or recognition of the right to be forgotten will kill the internet eventually. You know, when you think about how the internet has provided a public realm, public arena for anyone to freely share their expression and information. You know, think about it. If only positive information or nice information about somebody are allowed to survive, you know, that's not the internet anymore. So I'm very against the notion of you know, adopting this right to be forgotten in, especially in Korea and especially in Asia Pacific region. Continue. And in that sense, please, that's why we created a dynamic coalition on Publicness at the International APrIGF, and we also have a joint statement on the website. So if anyone's interested, please write your names and emails on this paper so that I can collect them after this session finishes.
Thank you. Thank you so much, Kelly. And we've heard from 6 panelists, and we still have plenty of time to take your questions and comments from the floor. And with those panelists being with several of those panelists being lawyers, I think they showed great restraint. So let's have a round of applause for all of our panelists. So let's start off. We're going to hear from Gilbert Andres of the Advocates for Freedom of Expression Coalition Southeast Asia, who has some responses and observations regarding this. And please prepare your questions. We want to hear from you. Please introduce yourselves, giving your name and organizational affiliation if you have one.
Actually, Mark, I have a question for the panel, but I'll just reserve it for later on. I'm Gilbert. I'm from APrIGF, Advocates for Freedom of Expression Coalition, Southeast Asia. And I'd like to talk about the Southeast Asian context. How many of you here are actually from Southeast Asia? I'm just curious. Thank you very much. So I want to talk about 3 points on the Southeast Asian context. First are the challenges. This is one of the moments where I'm not a panelist, so I'm just listening. I'm a participant, and personally, it has been depressing for me knowing about our challenges, our common legal challenges in Southeast Asia. For example, we have a strict liability regime in Southeast Asia. Liking, sharing, or even tagging is dangerous in Southeast Asia. And there's a strict liability even for intermediary webmasters. So it's a bit sad in Southeast Asia. But I don't want to dwell on the sadness and the depression. We should be aspirational, which leads me to my second point, human rights integration. Last year, January 2016, we had the establishment of the ASEAN community, wherein there's a free movement of goods, services, and people from one ASEAN country to another. And ASEAN is composed of 10 member nations. And if you look at it, sometimes we have that logical fallacy being presented by very authoritarian regimes in our region that human rights is a Western construct. And we thank our Western friends, our NGOs who are based in the West for stating that human rights is universal. You should have universal human rights in Southeast Asia. But I think it would be better, it would be more powerful if it's us Southeast Asian who will tell that yes, human rights is a universal right. Freedom of expression is a universal right. And the problem in Myanmar, in Thailand, in the Philippines is also our problem in Indonesia, in Cambodia, in Singapore. Would it be powerful if our fellow Southeast Asians would be saying that, would be advocating for that? Hence, we have this notion that the grave concern in one Southeast Asian nation, it's not just the concern of that Southeast Asian nation. It's a grave concern for the rest of the region. And that's what we call human rights integration. And we stated this principle in the Cebu Declaration last September 2015. In the Cebu Declaration, it really states why human rights is a fundamental human right, why freedom of expression is such a fundamental human right in Southeast Asia. And it was signed on by 10 NGOs from 6 Southeast Asian countries, mainly from the Philippines, Indonesia, Malaysia, Thailand, Myanmar, and now we have an NGO from Cambodia. And I'd just like to recognize some of our NGO members. So from Indonesia, we have the LBH PERS, and we have ADE, and the ICJR, Institute for Criminal Justice Reform, we have Erasmus. And from Malaysia, we have the Empower Women's Feminist Rights Movement. We have Mastura from Malaysia. And we have the MCCHR, Malaysian Constitutional Center for Human Rights. We have Luis and my friend from the Philippines. Yes, Lito Averia from PIFA, Philippine Internet Freedom Alliance, and me from the Philippines Center for International Law, Philippines. So we want to do human rights advocacy across Southeast Asia as a region. And we want to do that through amicus briefs. We want to file before our courts here in Southeast Asia. We want to do that through advocacy by making position statements. And yes, Mr. Tintan O from the Myanmar Lawyers Network, our youngest at heart representative. We want to do that. We want to file amicus briefs before our courts, although that's also challenging here in Southeast Asia. And we want to also make position statements before our legislatures. But I'd like to end with the third principle. We've been talking about freedom of expression, and I know we've been really taking it for granted. Why do we even talk about FOE? And I'd like to end with the Cebu Declaration. It states there that freedom of expression is a fundamental human right, since as human beings, we want to express our own humanity.
Thank you, Gilbert. That's inspiring. Yes, please, go ahead.
Thank you so much. My name is Xian Hong, representing UNESCO. I found this panel is very interesting because they have very divergent ideas. Some support the right to be focused, some not. I know UNESCO has a very core mandate promoting both freedom of expression and privacy now. And we have been exploring the very complicated relation between these two rights. Firstly, I want to share that I think we need to recognize that free expression and privacy are friends. They support each other, not always in a conflicting situation. For example, even in traditional journalism, the right to anonymity has supported the free expression. And now, if you look at the source protection for journalism, it's such a supportive framework to help journalism to function properly. So even right to be forgotten, we need to recognize the very positive component that it really helps to some people's safe communication on the internet. That's my one observation. And secondly, I think on the internet, and now it's the internet age, if something cannot be searched, it doesn't exist. So the right to be forgotten, although it's actually right to be delisted, but it does profoundly impact the access to information. And I'm not a lawyer. I like to look at it more from a larger social context and larger social implications. Imagine those people, individuals or institutions in power, they don't like some part of the history, records, archives to be searchable, to be accessible on internet. Then that part of story will just disappear from humans' memory. I mean, that's a part of the history, that's part of the cultural heritage, digital heritage, and archive heritage. We, as every human being, we need to preserve for the future generation. So that I think if you think about the larger social implication, you will realize that right to be forgotten should be really very carefully examined. And I totally can agree with several speakers that the public interest need to be prevailing. And I did raise this question to European, GDPR, one of the expert groups, and the former Spanish data protections commissioner. I asked them that how did you strike that balance in the GDPR between the free expression and privacy? They said that they do have an article. Article 72, I don't recall. They have a safeguard on free expression in that global data protection framework. But in reality, he said he doesn't find it's feasible to have an overarching law, because you do need to look at them case by case. Because in every balancing cases, there are no one solution for all. So that's why I think this discussion was very interesting. I mean, with lawyers, with judges, jurisdictions. I mean, they also imagine keeping in mind the international standard and also public interest. We do need to take a case-by-case approach. Thank you.
Thank you. The woman behind you.
Thank you. Yeah. Hi. My name is Bishaka. I work with a non-profit in India called Point of View. And I want to make an intervention because I think this is one of the hardest issues, and I'm not sure where I stand on the right to be forgotten, but very similarly to what you were talking about. So I would like to say, first of all, that I agree with Professor Park on certain things, that I think the right to be forgotten is being used in contexts where privacy legislation, etc., would actually work equally or more effectively. In the early days after the Spanish case, I looked up and did some research on a number of cases and found that the right to be forgotten was being used also to correct journalistic errors, right? So you might have a journalist who'd made a mistake in reporting something, and then the person, instead of going to the newspaper, perhaps feeling that they couldn't get redress from the newspaper, were now using the right to be forgotten. So I agree on the one hand that we can't have this kind of umbrella right which makes up for all sorts of errors that should be corrected by other things actually. But at the same time, I do want to say that there are certain things that I think of which are not merely reputational but are actual harms. And I think here we are talking about non-consensual intimate images being circulated, some of the examples like the rape one, etc. And here, for me, I would say that in a context like in the country I live in India, if you were to try and go to court to get something removed, it might take you 10 years, right? And that is not at all meaningful in terms of justice, or in terms of what I as an end user might want, which is my non-consensually circulating images. They can't keep circulating for 6 years, 10 years, etc. So in those contexts, I would, where harm is involved, not just reputation, but sort of harm leading to reputation, I would strongly support measures which give us redress, right? And I want to say one thing here, actually. I was thinking about it. Because we talk so much about human rights, and I think we often focus on the rights part of it and we forget the human. And the truth is that there are human beings on the other side of this, right? And for some of us, we can't wait for what is the sort of intellectually or conceptually best solution. We have to go on leading our lives, and why can't we have not just the toughest solution in the planet, but why can't we have the easiest solution for justice?
Okay, thank you. The gentleman at the mic there.
Thank you. Is it on? Yeah. My name's Winston Roberts. I'm speaking not for a government here, but I'm concerned. I work in the area of national libraries, national archives, And I'm concerned about the preservation of the official record of what happens in any country, any given country. Part of the official record is in the National Archives, is record of government processes, record of legal decisions, and a part of the official record of the country is the cultural record, which is in publications and reports of news media, which may be also held in the National Library. And these things we are encouraging all countries to digitize, because digitization of heritage documents is one way of preserving that record, especially in countries where there are natural disasters which might lead to destruction of heritage documents, or when there is simply too much information to be accessible by physical means. Digital access to information is faster and more just and more equitable for anyone to find information that they need. The laws of many countries do specify that heritage information should be made available to citizens, private information about them should be made available to citizens, and these laws should be respected and take into account matters like defamation and privacy and so on. The situation that we're discussing in this workshop is so fluid, it's evolving in so many different ways that I would hesitate. I'm not a lawyer, I cannot possibly comment on these matters, but I would caution you against neglecting the importance of maintaining an official record of the country. Whatever happens in the country is part of that history. And it occurs to me, I agree with what Zhang Hong from UNESCO said, and I agree with the speaker from India. I'm sorry I forget your name, madam, but I agree with what you both said, that all of that is important. It occurs to me maybe what we need is to remember laws on defamation, laws on privacy, and maybe we need to study the possibility of having limitations and exceptions for private information to be preserved, but at the same time the public interest to be preserved, to strike a balance. Maybe there needs to be some sort of commission of inquiry into the balance between privacy and public interest. That's all.
Thank you. Thank you. The gentleman at the mic beside you. Yeah.
Hi everyone. My name is Janelle. I'm from the University of the Philippines. I'm a journalism student, and I'm one of the youth fellows of this program. So basically my question is, I'm a journalism student, and for me, I'm really advancing our right to access information. But I believe that, but as you can see, the case of the Philippines, the public figure is, the definition of public figure is so sweeping that it actually, it currently actually is defined as anything that is newsworthy. And who the hell among us knows what is newsworthy and who is public figure? You know, those are two sweeping, two slippery terms that I wasn't able, I don't know if you guys defined public figure or the, what do you call this? Public figure, but you know, I wasn't able to get it if you were able to define it. But if not, I'll be glad to know if there are international standards as to what is the limitation of public figure, because as the woman from India said, our madam said from India, that while there are humans in this side, there are also humans on the other side. And while we have our freedom, or while we have our right to access information, they also have access for their private information. So yeah, what should be the limitation of public figure? How should we define it? Thank you.
Thank you. And very interesting question, I think, with a wide variety of definitions. And as the point was made, sometimes in trying to not be a public figure, you also become one. Let's hear from Malaysia. Louis, last comment, and then we'll go to the panel to wrap up.
Thank you, Mark. I'm Louis from the Human Rights Center from Malaysia. Okay, the concept of the right to be forgotten is still very foreign in Malaysia. It has not been tested in courts nor in the legislature. I beg your indulgence for me to just say a story to put into context what we are discussing today. So there's a boy who is like 19 years old who made a rape joke in a group chat about his classmate, and then another member of the group chat screenshot that conversation and put it on Facebook. There's a real case scenario in Malaysia, by the way, and that post went viral over the night. There's a lot of shares, thousands of shares, and also alternative media has picked up on it and also put in their own stories, because these media likes very hot topics, so they share this story. And then since then, because that post was accompanied with his name, the boy's name, now that every search engine about his name would come up with that story about him making a rape joke. And he is a 19-year-old boy, and that would stick with him for the rest of his life. And as far as I know, he is a law student and he wants to become a lawyer. And that, I believe, that has affected his life entirely, and his prospects of getting into university as well as to getting an employment is affected, it has been derailed entirely. And also, I believe that a lot of social media vigilante picked on it, condemned on it, gave their opinion on it, write articles about it, about how rape joke cannot be tolerated. And I don't see any way that he could defend himself without the right to be forgotten. Defamation laws cannot help him. So I think this perspective has to be put into context in our discussion, instead of just focusing that right to be forgotten is an infringement on the freedom of expression. But how about a boy's life that may be affected if he's not granted the right to, let's say, delist from the search results of Google engines? Thank you.
Okay, thank you for that. We'll turn now for any final comments in response from our panel, and then we'll wrap up.
In the order of presentations, I agree with the intervention from Malaysia just now about child's posting, and also posting of, for instance, posting about sexual crime victims, and also images of sexual activities. These are harmful information at source. They need be reducted even they need be reducted at source. Suppressing circulation doesn't help abating that problem, abating those harms. You need to start. I mean, if only if some people have access to the information, they'll wield power over your lives. So whether it's made available widely, whether it's made available in a limited circle, your life will be ruined. You need to take action at source. And in some sense, if only a small number of people have access to that information, it will become a greater threat to you than when everyone else knows about it. So I think that that should be the approach that we should take. For instance, we heard about the Philippine case of a rape victim. If Philippine criminal procedure law doesn't have a provision allowing reduction of the names of rape victims, then it is those laws that have to be upgraded. Korea has that provision. Because once the name makes into the public records, it is harmful information that can affect the rape victims, even from the beginning. There, the victim should either testify in an anonymous capacity. There can be various ways that the information can be controlled at source once you know that it is harmful information. And trying to go back in time, or trying to suppress circulation in only certain media will not really will not be a proper way to address those harms. And at the same time, I have no problem applying right to be forgotten to those exceptional cases about sexual crime victims or children's postings. I included that in my presentation, that children legally don't have right to consent, don't have power to consent to disclosure of private information about them. Sexual crime by nature takes place in a private context. Prostitution by nature is geographically a private profession. There are these privacy arguments that can be made about those contexts. Right to be forgotten is not about that. Right to be forgotten is about the information that is made available to the public either voluntarily or by your conduct that necessitated a public attention. The prime example is a criminal activity. So that's why we do not need a right to be forgotten. We should sharpen our conceptions of privacy.
I think I would add just briefly to that. I think from the U.S. perspective, we're probably the least tolerant of regulations of speech in general. And I would say that with respect to the right to be forgotten specifically, that it shouldn't necessarily be used as a tool to address, I think as Dr. Park was saying, other societal issues. So for example, it is not uncommon in the United States, even though there is absolutely no legal requirement, no sort of right to be forgotten, or no legal requirement that information be taken down, it is not uncommon for news organizations to receive requests from individuals, particularly about older stories, to remove them or to change information in those stories. This typically arises in the case of criminal convictions that are quite dated. You may have an individual who comes back 10 or 15 years later and says it's difficult for me to find a job because when you Google my name, this Washington Post story about this crime that I committed is the first thing that comes up. It's certainly not difficult at all to feel sympathy for a person in that situation. I think the news organizations in the US that I work with take a bright line approach to that. They do not take a case-by-case approach. They take a bright line approach to that, which is that, no, we do not remove content from our news archives. We might add a correction. We might, if appropriate, we might add additional information to help supplement the record if that's an appropriate thing to do. We're not going to remove that information, which has been part of the public domain, from the public domain. Isn't a better solution societally, from a societal perspective, to remove some of the stigma of having a criminal conviction on the record, which is a pretty common thing in the United States? Isn't that better than sort of wiping away this one instance of a criminal transgression from the past? So I think it is important to question whether or not at the outset, whether a government regulatory approach is the right approach to address some of the problems that are at issue here, particularly if there is a non-governmental approach. I think, for example, the posting of revenge porn is a violation of pretty much every term of service of every ISP, of every social media provider, that they will willingly remove that content if requested because it's a violation of their terms of service. There's absolutely no need for a governmental mandate in that way. So I think it's important to not use a sledgehammer to kill a fly, particularly when on the other side of that you're dealing with access to information and free expression.
Toshiki, are you there? Toshiki?
Yes, yeah.
Okay, you have your last 1 minute.
Okay. 1 minute.
Go ahead now.
Okay. All right. From company's perspective, we are doing our own efforts. In particular, we are we believe education for students and consumers, for our users, is very much important, and how to maintain online safety, including how to act on the internet, is also important. So we are doing some kind of a program called Web Rangers and so forth. I don't have time to explain the whole program about this, so please search after the session, Web Ranger and so forth. But we are working with students, teachers, and so forth, and to know about the risks in online behavior and so forth, so that people can avoid troubles. That's one thing. And regarding criminal conviction, apart from that, education, I think there is some demand to rehabilitate criminals in society, but I think it's something like more criminal rehabilitation policy. It's not something like making a blanket deletion right on the internet. So narrowing down the policy issue is important, and it's effective, and the concentrate on some issues is also important. And because I was a lawyer before joining Google, I had some experience to save criminal victims too. And through these defending activities, the news on the internet is pretty much useful for me. In particular, collecting evidences or how to prove the repetitive offenses to the police and the prosecutors and persuade judges, and why I'm working for these criminal victims. So that's my 2 cents. So based on your experience.
Okay, thank you so much.
Right. We've seen that there are concerns when it comes to the boundary, the extreme boundary of right to be forgotten. And I think that a proper regulatory approach allows for more dialogue at these edges, and that we need to talk more about what those boundaries are. Do those boundaries need to be set by society? Do they need to be set by professional organs? Where does this happen? But we also have to realize that there are instances where justice, substantial justice, is not afforded to people who have no access to these remedial measures. And for that's where we come in. And hopefully we find a balance later on. But we've realized also that something has to happen in the meantime. We can't just leave things hanging.
Yeah, definitely there is a need to strike a balance. Of course, where there are laws, like in the case of sexual offense victims, we don't need a right to be forgotten bucket for that, so which could catch everything. I'm sure none of us want a sanitized internet where we only have good things. I mean, then we'll only have cat videos on internet. I'm sure we don't want such a thing. Thank you.
I understand that there are like extreme cases where the victim of the information circulation should be protected, and as I already said, in Korea we have many measures that the victim can attend to. So I want to point out that like this right to be forgotten, or these laws or regimes that protect a person's reputation tend to be abused by those public figures or people in power, or professionals or companies, to wipe the internet out of their bad reviews about them or criticism about them. And most of the time, I think it's more than 90% of the time, the people or the entities that make those kind of right to be forgotten claim or defamation claim are those powerful people or public figures. So I think, especially in Asia Pacific region, where the reputation is very well recognized, I think we should be careful not to broadly apply the right to be forgotten, especially in our region. Thanks.
Well, we hope we've given you some food for thought. I think it's now time for food for our stomachs. So we'll break. We thank you all for coming. This was a great turnout, and we thank again our panelists. Thank you.
Please make sure leave your names and emails on this yellow page.